established. Further, in Krishna Mohan Kul versus Pratima Mathi, at 3 of the compendium, the Honorable Supreme Court reaffirmed that both dominance and exploitation must coexist. In the no state, and hence no dominance. Secondly, much obliged, Your Lordship. It was held that influence becomes undue only when it destroys free will. Here, the corporate marriage program was purely voluntary, no penalties for non-participation. Therefore, it was lawful persuasion and not coercion. Thirdly, the conduct of the petitioner proves free consent. In Srishtha Devi versus Om Prakash, at the same page of the compendium, my lords, the court held that consent must be of marriage, family participation, written consent was executed, and no objection was raised at any stage, my lords. Thus, my lords, subsequent dissatisfaction cannot invalidate prior free consent. Council seeks permission to proceed with issue number 2. It is submitted means the it was categorically held that private bodies are not amenable to writ jurisdiction and Article 32. Also, in Federal Bank versus Sagar Thomas, of the compendium. No state action is involved. Thus, Article India. The petitioner voluntarily chose to marry, and no state interference is involved. Thirdly, Article 14 applies only in cases of state arbitrariness. In Ajay Hasya versus Khalid Mujib, at page 8 of the compendium, my lords, tests for state were laid down and none are satisfied here. The policy is uniform, non-discriminatory, and optional. Hence, no arbitrariness, no discrimination, and no violence, Your Lordship. If Council seeks permission to proceed with issue number 3. My lords, it is respectfully submitted that the petitioner is not entitled to maintenance or relief under PWDVA. Firstly, under section 125, in Chaturbhuj versus Sitapai, if my lords may please refer page 9 of the compendium. The Honorable Supreme Court held that the provision is meant to prevent destitution, not to grant undue benefit. Software engineer, she is gainfully employed, and there is no evidence of financial incapacity. Thus, the basic is not withdrawal bars maintenance. In Rohtash Singh versus Ramendri, at page 10 of the compendium, my lords, it was held that a wife withdraws without sufficient cause is not entitled to maintenance. Here, no legally sustainable subjective dissatisfaction. Cautioned against misuse of PWDVA in ordinary matrimonial disputes. In the present case, there is no specific incident of abuse, and there is no evidence of physical, emotional, or economic violence whatsoever with the petitioners. Thus, the statutory thresholds are not
You have said that there is no coercion and compulsion is there. But if we'll go by the problem at the initiations of that problem, some lines are, if I'm not wrong. I'm correct?
Yes, my lords.
So Mr. First she denied and she told like
Only when it overpowers the free will of an individual, my lords. And here our petitioner is gainfully employed as a qualified engineer, and she is 28-year old, my lord. So the program could benefit both the respondent and the petitioner. There is no single benefit involved. The benefit is for both of them.
Marriage is valid and subsisting. My lord, it is submitted that it is legally valid and cannot be annulled. Firstly, grounds for void or voidable marriage are strict and exhaustive. If my lord may refer to page 11 of the compendium, in Yamunabai Anantaro Adab versus Anantaro Shivram, the court held that validity must be strictly tested with statutory limits. None of these conditions are satisfied here. Second, consent must be free at the marriage. In Sureshna Devi versus Om Prakash, at page 4 of the compendium, that consent cannot be withdrawn retrospectively. Also in Alka Sharma versus Abhinesh Chandra, at page 5 of the compendium, Supreme Court held that post-marital dissatisfaction is not a ground for annulment of the marriage. Thirdly, strong presumptions in favor of the marriage. My lord, in Badri Prasad versus Director of Consolidation of the compendium, the Honorable Court held that law strongly presumes validity of marriage, which remains undischarged. Thus, the respondent number cannot be held liable. Council, permission to start with issue number 5. My lord, firstly, private entities are not amendable to constitute liability. In Federal Bank versus Sagar Thomas, at page 7 of the compendium, it was held that private companies are not stayed under Article 12. The employer is the private no public function. Secondly, policy decisions are not subject to judicial interference. It also employs the Union of India at page 9 of the compendium. Courts should not interfere in policies unless arbitrary or illegal. Council seeks permission to address issue number 6. My lord, this is the strongest preliminary objection. Firstly, Article 32 only lies for enforcement of fundamental rights. As already submitted in ZEEF telefilms, private disputes do not fall under Article 32. This is purely a matrimonial dispute, not a constitutional one. Secondly, existence of alternative remedies bar writ jurisdiction. Superintendent of Taxes at page 13 of Compendium, the court held that writ jurisdiction should not be exercised when effective remedies exist. This was reaffirmed in CIT versus Chabil Das, where the court warned again against bypassing statutory forms. Thus, the petition is a classic case of third matrimonial disputes fall within exclusive courts. Abdul Jalil versus T.A. Shahida at page 15 of the Compendium. The court held that family courts have exclusive domain over. Therefore, the Honorable Court should not entertain such factual disputes. Open floodgates, every matrimonial dispute would be converted into a constitutional claim. In light of the fact that the respondent may be pleased to discuss the AVA and pass any other order this Honorable Court may deem fit in the interest of justice. The respondents are grateful to the Honorable Court for its time and consideration. Much obliged, Your Honor.
Ma'am, one more question is there. But we are saying, but if she want to go to court relief of maintenance under section 25 CRPC or before JMIC, that domestic violence act, what would be your
Thank you so much for the question, sir. Sir, in the case which I have cited in the compendium also, a writ petition under Article 32 is not maintainable against against a company or a private person. Also, the Article 32, Article 12. So, Article 12 is not violated here as the consent was mutual, the discussions were mutual, and benefits were also mutual. So,
specific question from you?
okay,
And
sir.
domestic violence act, that is a maintenance. If you are claiming at one side that marriage is not voidable and marriage is subsisting,
Yes, sir.
so definitely section 125 CRPC and domestic violence, so whether she can seek that remedy. Take help of her.
Thank you for the question, sir. Sir, it is submitted that the section 125 CRPC requires proof of inability to maintain herself by the husband.
Remedy, but that is dependent on the facts of the case. And in this instance, if I will say that as per the case,
Yes.
she asked her,
Sir, in the present so related to the case I have mentioned, Chaturbhuj versus there is no essential
opposite counsel has raised some issues regarding consent form that was signed by the petitioner and the article 32 that the a proof of a valid marriage mutual consent under law. Also, signing was executed under continuous corporate pressure and indirect coercion, which violates the free consent. The consent form not override the fact that it reflects intention or awareness. Document itself lack legal sanctity. Next issue that was raised for Article 32, that it is violation is there or not. Opposite respected counsel stated that state corporate entity is a private entity, so we cannot say that violation of fundamental right is there. So my lord, even if the respondent does not strictly fall within Article 12, the Honorable Court under Article 226 can still exercise its jurisdiction against any person for enforcement of fundamental rights. And the next amendment of Constitution, it is written and expressly mentioned that state shall not deny any person equality before law and equal protection within territories. Maintenance if she's able to maintain herself, and employment here alone is not just a bar. I would like to quote a case of the same cause that had been stated, Chaturabhuj versus Sita Rai, page number 17, paragraph 3.1. As the opposite counsel has interpreted that statement on their own side, but I think they forgot the ratio of that statement. When here Supreme Court clarified with the object that Section 125 CRPC is to prevent destitution, even when the wife is capable of earning. And Section 125 CRPC is entitled to maintenance. Thus, the focus should on economic vulnerability, not on circumstances of marriage. I would like to invite my learned counsel to address the remaining issues.
One question from you. Pertaining that if she is living with her own consent,
influence our whole case pertains to focus to Zangita faced the economic influence and the corporate pressure. And Your Honor, I would like to state that in today's corporate reality, pressure is no longer explicit.
Sorry, I'm interrupting you. Sorry for that. Thing is that I'm not going in the first scenario. Marry the I think that after marriage, she left that matrimonial home and living with outside that matrimonial relationship with her own consent. Then I'm asking.
Your Honor, this is not clarified in the facts actually that she is living alone or she is living separately. And I would like to end this that in today's corporate reality, pressure is no longer explicit. It is structural. Employees are not forced, but the present case is a classic example where career would send a message that subtle coercion is acceptable as long as it is cleverly disguised. The petitioner stands before this honorable court seeking not sympathy but justice for a consent that was never truly free. Now I would like to invite my learned co-counsel. Much obliged, Your Honor. The counsel seeks permission to approach
Your Honor, this is not a case of valid free marriage. This is a case where consent was reiterated from the very beginning. Exercise the legal right to consent was created due to influence. company cannot be held liable because it did not do anything wrong. Employees will lose the freedom to make personal decisions. Their dignity and autonomy will be compromised. The position is very simple. Use this position to direct real pressure and interfere. Respectfully submitted. Coming to issue number 6, maintainability. Petitioner argued that the present petition is not maintainable before the Honorable Court. Your Honor, this case goes beyond private dispute. Corporate environment that influence personal decisions are not right. Sangeeta, the petitioner's freedom at stake. So the position is that this is not a family matter. It has a constitutional dimension, and therefore the Honorable Court has the full jurisdiction to hear it. Your Honor, if you have no further question, I would like... All right, thank you so much.
Very precise, because we have heard arguments of both. Because but that opportunity used to be not given.
Written in my memorial, point number 1.3 at page 13. Voluntary conduct of the petitioner itself establishes free consent. It is not the matter of where the form was signed or not, or whether is it legally binding or not. The petitioner participated in the marriage ceremony without protest, and there was no objection raised prior to the marriage. The ceremony was conducted publicly with family participation, and it was signed. The written so policy does not fall within the ambit of undue influence if we held the respondent number 2 the company liable. There is no dominant position or exploitation has been established. Corporate incentives do not amount to legal coercion. I've cited a case in Rohtash Singh versus Ramendri at page 10 of the compendium. It was held that a wife who withdraws from the husband's society without sufficient cause is not entitled to maintenance, and the petitioner has not established any legally regarding Article 2 is invocable versus Union of India at 15. It was reiterated that writ jurisdiction cannot be invoked against private entities unless they fall within the ambit of state under Article 12. And the present dispute arose between private individuals. Employer is a private entity, and no state action or constitutional infringement is demonstrated. Thus, regarding the voidable marriage, I would like you to refer point 4.2 of issue 4. alleged lack of free consent does not satisfy the threshold under Section 21A of HMA Act. The petitioner voluntarily participated in the marriage ceremony again. No force or deception regarding the nature of marriage is alleged, and the alleged pressure is indirect and subjective. It was also established in that post-marital dissatisfaction is not a ground for consent. Regarding the program being wrong, I would like to corporate policies offering incentives do not amount to coercion or undue influence. In the present case, the program is optional, no adverse consequences exist for non-participation, and the incentives are uniformly available. Thus, the policy does not cross the threshold of illegality or coercion. And in 5.3, freedom of contract and private autonomy protect employer policy. The educated and economically independent employer. There was no inequality of bargaining power as brought up by the petitioners, and this was not employment. Versus Union of India at page 9 of the compendium, the SC held that courts should not interfere in policy decisions unless they are arbitrary, unreasonable, or violative of state laws. Hence, is untenable, and it is submitted that if such petitions are every matrimonial dispute could be brought before the Supreme Court, statutory forums would be rendered redundant, and the distinction between public law and private law would be lords. Council is grateful for the allowance of the submissions, my lords.
I am very happy to hear the very good and at this stage of we can say very hardworking and we have to build future aspect and success in your field and excellence.
Their efforts has brought all of us over here. So for them, can we have a huge round of applause, please? On this note, I would like Professor Dr. Ramakant Dwivedi ji and Professor Dr. Umesh Gupta sir to please come forward and facilitate our volunteers, please. Raj and Sanjana Kumari. Two Sanjana Kumaris with us. Can we have the group photograph and be quick, please? Thank you. All of them, I announce their names. Can we have Priyanshi Chaudhary and Khushi Mandyan? Lavesh Bhardwaj. Can we have Banu, Akshat, Raghav, Diksha, and Kamaljeet, Ranveer, Tanish, Abhishek. Abhishek. Thank you very much, sir. Thank you very much. I request Professor Dr. Preet Singh, sir, guidance was invaluable. And to everyone present over here, thank you so much for being a part of this journey. Now, as we that, I would like to request our judges